Welcome to Learn Shorthand Typing with Vikas Sir. The legal magazine for Punjab and Haryana High Court and all other allied courts. 800 words, 80 to 100 words per minute. Be ready, start. Applicant and respondent were working together in a private company. The respondent, who was working as a personal officer of the company, was a married person having 2 children, and the applicant, aged 33 years, was unmarried. Constant contacts between them developed intimacy, and in the year 1972, applicant left the job from the above mentioned company and started living with the respondent in a shared household. Applicant family members, including her father, brother, and sister, and also the wife of the respondent, opposed that live-in relationship. She has also maintained the stand that the respondent in fact started a business in her name and that they were earning from that business. After some time, the respondent shifted the businesses to his reliance and continued the business with the help of his son, thereby depriving her right of working and earning. Applicant has also stated that both of them lived together in a shared household. Further, it was also stated that the respondent took a sum of rupees 1 lakh from the applicant, stating that he would buy a land in her name, but the same was not done. Respondent also took more money from the applicant to start a beauty parlor for his wife. Applicant also alleged that during a year 2006, respondent took a loan of rupees 250,000 from her and had not returned. Further, it was also stated that the respondent all along was harassing the applicant by not exposing her as his wife publicly on permitting to suffix his name after the name of the applicant. Applicant also alleged that the respondent never used to take her anywhere, either to the houses of relatives or friends of funds won. Applicant also alleged that the respondent never used to accompany her to the hospital or make joint bank account, execute documents, etc. Respondent family constantly opposed their live-in relationship and ultimately forced him to leave the company of the applicant, and I was alleged that he left the company of the applicant without maintaining her. Next para. Applicant then preferred criminal miscellaneous number 692 of 2007 under section 12 of the DV Act before the Additional Chief Metropolitan Magistrate, Bangalore, seeking the following reliefs. Next para. Pass a protection order under section 18 of the DV Act prohibiting the respondent from committing any act of domestic violence against the applicant and her relatives, and further prohibiting the respondent from alienating the assessed both movable and immovable properties owned by the respondent. Next para. We may at the outset refer to the facts of both the cases giving the rise to the present appeals. The State Pollution Control Board Odisha bracket में for short the board bracket close is a statutory body constituted under the provisions of the Water bracket में Prevention and Control of Pollution bracket close Act 1974 bracket close open for short the Water Act close and the Air Prevention and Control of Pollution Act 1981 for short the Air Act stop. The board its exercise of its powers introduced bank guarantee system wide its resolution number 17617 dated 18th August 2003. The said resolution reads as under para. A number of acts and rules have been enacted for the purpose of preventing pollution from different sources and for protection of the environment stop. Basing on these acts, the Central Pollution Committee Board, state government and the state pollution control boards are empowered to file complaint cases resulting in the closing down of defaulting industries through disconnection of electricity and water supply. There is hardly any other provision to pressurize defaulting industries to install required pollution control system or to impress upon them to upgrade their existing pollution cannot system as per to comply with the prescribed norms. The Honorable Supreme Court of India, while dealing with different public interest litigations on environmental matter, has laid down different principles in order to pressurize the industries to control pollution or to restore the environmental degradation through polluter to pay principle. Next para. It has been experienced that the orders of closure and disconnection of electricity etc. served on the industries at times create social problems like non-payment of wages to its workers due to lack of adequate provisions in the Act. Stop. Under such prevailing circumstances, a new instrument, timely bank guarantee system, has been introduced by the West Bengal Pollution Control Board. Such an imposing of bank guarantee has already come up before the judicial scrutiny in the Honorable High Court of Kolkata in the matter of W.P. 5938 of 2000, wherein the latter has nationally endorsed the state board to monitor the policy of bank guarantee towards effective pollution control. Introduction of bank guarantee system is in respect of defaulting industries within the purview of State Pollution Control Board. Odisha was under the active consideration of the board for some time past. This matter was placed before the board in its 75th meeting held on 27/6/2003. After going through the concept paper prepared by the CPCB, the board unanimously resolved to introduce the bank guarantee system for the defaulting industries. Full stop.